On to this developing story now. The second and final day of the Privy Council hearing for recording artist Adidja Palmer ended earlier today, and the council is expected to present a verdict in short order. Trisha Gay Kelly has been following that story.
An acquittal or a retrial. Vybz Kartel's trial verdict lies in the balance as the United Kingdom Privy Council prepares to determine the entertainer's fate. The court hearing, which started on Wednesday, concluded on Thursday, with the council expressing its hope to provide a verdict soon. Defense attorney Bert Samuels says it would not be fair for his client to be tried again.
Retrial for what? They've gone 12 years and more in custody. Some of them have served half of their sentence and others a third. It would be totally unfair, for want of a stronger word, to ask them to go back in their pockets, pay for more lawyers.
Samuels adds the Constitution of Jamaica states that every citizen is entitled to be tried by an independent and impartial tribunal.
A jury is that tribunal, and if it is found that someone has been trying to bribe the jury, that jury is now what we call in law tainted. And therefore, the person would have lost an opportunity to be tried by a jury of persons who have committed and kept their oath to return a true verdict according to the evidence and nothing else.
And in agreement with Samuels is attorney at law Michelle Thomas, who believes the case is leaning more towards Palmer being freed.
They can't ask someone to dismiss their mindset from something that they're already exposed to. And because this is a high-profile case, and the length of time that this case would have been in the forum, in the public, it would be hard for any retrial to be fair. So I would think that the safest thing to do is to just quash the conviction.
Though some may say the same is true if the artist should be freed while sufficient evidence was provided, she explains that this should be blamed on lack of procedure.
And when those rules and procedures are not followed, it's not just about whether you're guilty or innocent, but whether in order to reach that verdict, whether everything was done within the rights of the individual being charged.
Samuel says he's expecting that the verdict potentially may be decided by summer of this year.
Oh, me look dark now, man.
I'm not angry. Vybz Kartel is just a nice person, a jovial person, a happy person. It's just time to heal the society right now.
No.
Do you think you owe a responsibility to the children on a whole, or just public in general, in terms of your lyrics and content and all of them stuff? Do you think you need to be censored?
No, I don't, you know what I mean? Because that's what I'm trying to tell Jamaica people. I'm an artist, I'm an entertainer. I get paid to entertain. I'm not a religious leader and I'm not a political leader. You know what I mean? I shouldn't be held responsible for growing a child. Responsibility should be held with the parents.
Before I go into the lecture, I'd like to ask anyone from the audience to answer this question. Who is Vybz Kartel?
Welcome back to my channel, everybody. I just want to take a minute to just big up all who subscribe and all who view and all who press the like button. All who just big up on yourself, alright? Right now we're going to get into the final day of Vybz Kartel and co-appellant final appeal at the Privy Council in London. Alright, so let's get your popcorn and your sodas. We're going to jump in it right away.
Let's go.
You, Sauti, an attorney representing Vybz Kartel and his 3 co-appellants at the UK's Judicial Committee of the Privy Council, has argued that even if their appeal is successful and a retrial ordered, a fair trial would now be impossible. During the second of a 2-day hearing of the 4 men's final appeal on Thursday, Sauti spoke to the potential difficulties of a retrial in light of matters such as the high-profile nature of the trial, perhaps triggered by Kartel's notoriety in Jamaica's music scene. Those difficulties have not diminished. They have become greater because of passage of time. This is something that is now high-profile. In our submission, that submission supports our argument that there is no point remitting this, because a fair trial is now very difficult, impossible, we would submit, Sauti said. On day 1 of the appeal, Isaac Buchanan, another attorney for Kartel's side, had argued that the conviction of the 4 men should be quashed. There is no cure, no proviso, or no thought of a retrial or a second bite of the apple where the unfair trial right was breached in manner that it did, he had said. In March 2014, Kartel, whose given name is Adidja Palmer, Sean Storm Campbell, Kyra Jones, and Andre Matsu St. John, were convicted of the murder of Clive Lizard Williams in the Kingston Home Circuit Court. In addition to cell phone evidence, prosecutors had relied on the sole eyewitness, Lamar Chow, who testified that Lizard was murdered at Kartel's home in Avondale, St. Andrew, after he and the deceased were summoned there over a missing, unlicensed gun. Lizard's body was never found. After the Jamaica Court of Appeals largely upheld their conviction in 2020, the four men moved to the Privy Council, Jamaica's highest court. They have alleged that the crucial cell phone evidence was improperly obtained and that the trial jury was tainted and compromised by attempted bribery and later pressured from the judge to reach a verdict. On Thursday, questions of the jury tampering again dominated the morning session. Juror Livingston Kane, who in late 2022 was found guilty of attempting to pervert the course of justice by offering a $500,000 bribe to the jury forewoman to influence other jurors to return a not guilty verdict in Kartel's case, was allowed to remain on the jury panel after the allegations were made in 2014. Jamaica Jury Act requires at least 11 jurors for a properly constituted jury, so discharging Kane would have meant that the trial could not continue. As a female juror was discharged earlier, that female juror was allowed to leave the trial after she expressed fear for her son, who was at the time incarcerated in the same prison as the defendants. King's Counsel Peter Knox, who appeared on behalf of the prosecution, argued that if the jury tampering attempt had been allowed to derail the trial, then the whole legal system and jury system could be brought into disrepute. He doubled down on his assertions that the judge acted properly by not discharging the juror because it would not have been apt to carry out an investigation of the tainted juror at the time. He said that the judge was confident that none of the 10 jurors had taken a bribe, and further asserted that jurors are bound to carry out a public duty. Knox submitted that the judge's actions were not capricious in the exercise of his discretion and therefore fair in not dismissing the tainted juror. The judge is caught between two evil solutions, he noted. But as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably and rationally in making these decisions, as long as they are satisfied that there can be a fair verdict, the less of two evil is to go ahead and get that verdict rather than say trial of no verdict, he continued. He argued that the judge's action and instructions minimize bias, making it essential to consider the overall conduct and outcome of the trial, including the acquittal of the fifth accused, Shane Williams, and the overwhelming evidence against the other four men. Knox championed the jury's ability to discern the guilt of different defendants, which, he said, demonstrated their capabilities to judge fairly based on facts despite the bribery attempts. However, in the afternoon session, Southey challenged the prosecution's assertion that there was no risk that the jury was infected by bias. Conscious bias is a very real problem here, he said. Even if a jury says to themselves, I understand that this looks pretty bad, that a bribe was offered to us, but I understand what the judge has said. I need to put that out of my mind. That is very difficult. As a matter of human nature, to stop yourself being influenced by it, that is how unconscious bias works, he said. The Privy Council, which assigned a panel of 5 judges, Lord Reid, Lord Lloyd Jones, Lord Briggs, Lord Burrows, and Lady Simler, to hear arguments in the case, has now adjourned to consider its decision on the validity of cell phone evidence, whether the attempted bribery compromised the trial, and whether the judge handled jury deliberations properly. After an appeal hearing, the judges retreat to deliberate, each sharing their initial thoughts, starting with the most junior to prevent influence from seniority, according to the Privy Council website. They aim for a majority decision, not necessarily unanimity. One judge drafted the primary judgment, reflecting the majority view, while others may write concurring or dissenting opinions. The judgment is publicly announced on a scheduled date, typically 12 weeks after the hearing. Kartel, 48, has been in jail since September 2011. He must serve 32 years and 6 months before parole eligibility. Alright people, after hearing day 1 and day 2 of the final appeal for vybz Kartel and co-appellants, what you think? You think them stand a chance? You think them all come road? Is it the right decision Isaac Buchanan making, like not taking the retrial? And what about the judge, Justice Lennox Campbell, and all the questionable decisions that he has made? And what about the jury? They have been bribed from about November and until March. They never find it fit to tell a judge or bring it to somebody's attention. And last but not least, what do you think about our justice system? Thank you for listening. Thank you for watching. MSC TV, round here we talk facts, no fiction.
I may say a Pancho Khalifa. I may rep MSC TV, round here so we talk facts, no fiction. You see, Pri? Yeah.